Okay, how's that? Lightner headset. Doesn't look like it's working either. Is that working now? I think that's working. Yeah. Okay. Yeah, all kinds of problems here. I'm not sure what's going on. I go away for the weekend. Maybe the gremlins got in here. So I don't have my normal camera and I can't use my normal mic. So hopefully this will be fine. I'll just start over from the top. Today we're going to be talking about insufficient medical evidence. This is a very frustrating reason for denial that you can often get for a CPP disability case. I'll talk a bit about what it means if you get this type of denial and the type of things you can hopefully do to win on your appeal. So let's bring up my notes here. And we should be fine now that we got some sound. I'll have to figure out what's going on. I might just have to reboot the whole thing, but we won't do that for today. We're fine for today. Okay, so let's talk about what is medical evidence in a CPP disability application. This may seem kind of obvious, but the type of medical evidence that they are looking for are going to be more often than it'll just be more than the medical report that you send in. A key thing that you can do with the CPP disability case is just send in your medical report. That is something that's part of the application that the doctor fills out. That is medical evidence. It's not always, sometimes it is the best medical evidence for your case, but other times it is not. And it may be insufficient on its own to get your case approved. So what else can you look for in addition? If you've sent in the medical report and they're saying it's insufficient, well, a big thing that I like to focus on is always getting the family doctor's clinical notes and records and have those submitted as well. That's a big one. I don't file any CPP disability case without getting family doctor's clinical notes and records, or whoever the main doctor is. Usually it is the family doctor, but if you have a specialist that you see more often than the family doctor, then maybe we get that. Very important to get those records going back in time, as far back as needed. For example, I'm working on a case today, and it's a very difficult case. It's going to be very hard to win because we're having to go back 10 years and prove a disability that started in 2015 for someone who went off work in 2009. So there's lots of gaps there that make it very difficult. So like we had to get the family doctor's medical records going back to before 2009. Makes the case very difficult. But part of what they're claiming in that case is insufficient medical evidence just from the time periods involved. Now, other things, like in addition to your family doctor's file, now your family doctor's file will often include reports and things that they've gotten from other doctors and the like. And that can include things like MRIs, blood work, test results. Like that's why I like the family doctor's file, because it often has everything in it. Now, the key thing is whatever the medical evidence you've provided, it must show that your condition prevents you from working regularly is going to be the key thing. So why is Service Canada saying it's insufficient? It's just a simple way of them saying that we've reviewed your records and they don't prove your case under the legal test. Now, there can be different types of insufficient. It may mean simply that there's insufficient evidence of the disability itself, or there may be evidence of the disability, but insufficient evidence that it's prolonged, that your condition will be prolonged. You have to prove both things. It's not enough just to have a severe disability. You have to also show that it's not going to get better anytime in the near future. Now, the common reasons, so sometimes your doctor just doesn't give any details. Some doctors will focus on just talking about the diagnosis, whereas CPP disability is not as concerned about the diagnosis. They're more concerned about the limitations that arise from the diagnosis and the associated symptoms. So if the language and a lot of the medical evidence you've provided is just focused on treatment and diagnosis and not on how it affects you on a day-to-day basis, that can be a weakness and can result in this kind of insufficient medical evidence denial. And often, if you're just relying too much on your own information and not enough on medical, than like doctors' medical reports and things. And that is also a reason when they would say that it's insufficient. They won't accept, very limited that they're going to accept information from you about the medical condition, other than the important part, though, is talking about how it impairs you on a day-to-day basis. That is a legitimate thing for you to be giving evidence on. But in order for you to do that, you still must have a doctor kind of backing up what you're saying and helping make the link between the medical condition and the impairments that you're talking about. Okay, so just to repeat, like they're really just saying that you don't meet the eligibility when they say there's insufficient medical. And again, this diagnosis is not disability and the functional limitations must be clear. All right, so some mistakes you could make here is only sending in a doctor's letter or the medical report form that's requested, failing to make that link with work, incomplete medical records. Like it's one thing to say I'm going to give my family doctor's file, but you do have to go back far enough to cover the period in question. So for example, the case I was talking about here that I was working on today, we had to go back to 2009. That's when the person last worked. And if we were lucky to be able to get those records, but if we couldn't get those records, then we would have no chance of winning this case at all, because you need to have complete records going back covering the period in question. All right, so how do you respond to this type of denial? Well, one thing you can do is request the CPP disability file. I'd like to put a little star by that because I put that in here, but I don't always do this anymore. For the first reconsideration, just for practical reasons, because they're slow to get you that file. You can burn your whole 90 days. You're often better just doing a reconsideration based on the denial reasons in their letter and then just moving on to the next phase, quite frankly. This is what I tell most people that hire me now, is we're just going to breeze through this reconsideration step, because I've found that it is generally going to be very difficult to get a case overturned in the reconsideration phase. We're better off getting into the appeal before the tribunal, where we'll have more information and can do a better case. And it's faster because you can really get hung up in this phase waiting for the CPP file, then waiting for doctor's files. You're often better just to get through that step and get on to the tribunal, because once you go to the tribunal, it does trigger a requirement for them to get you a copy of the CPP disability file, which they will do much faster. They're slow to get it to you often if you're just requesting it, but if it's going to be coming as part of the reconsideration, as part of the Social Security Tribunal file, you'll get it almost immediately. So that's why I say it's often better just to get to that phase, get a copy of that file, and do your appeal there. You can still have your case approved before the tribunal, even if you are at the tribunal phase. Your case can still be approved before the tribunal hearing. Evidence gaps are a key thing. These are something you have to just learn how to look for. Like what is the evidence that's missing that is possible to get? That's something you want to look for. Sometimes they'll identify it for you. Like the evidence gap may have been like when the person hired me for the case where they have to prove their disability by 2015 and their last time working was 2009. They had no evidence going back before 2020. So that was a clear evidence gap that I identified and worked to get those records going back to like 2007 or so. That's an obvious way when they would write to this case and say that there is insufficient medical evidence, then we provide that. Now, even getting them that, in this case, even getting them that evidence did not help. They still are saying that it's not good enough. And so now we're having to go forward with the tribunal hearing. All right, now you can consider other assessments. We do this sometimes for clients, depending on the situation. Sometimes this is needed to do other assessments to get information that just doesn't exist. If you need like a vocational assessment, or maybe some other type of assessment, like maybe some type of cognitive assessment that can document the difficulties you're having mentally with doing things on a day-to-day basis. All right, so just to throw in here some appeal strategy tips. Key thing with CPP disabilities, always be mindful of the 90-day deadlines to appeal, and make sure you get your request for appeal in as soon as possible. You don't even have to wait the 90 days. You can get your request for appeal in right away. Once that's in, the deadline clock really stops running, and they'll give you additional time, even if it goes beyond the 90 days, to give more medical information. So that is something that you should do. But always, always, always get that appeal in within the 90 days. Do not try to rely on them granting extensions of time and that kind of thing. They don't always do that, and they often, if you don't have a good reason for missing the deadline, then you won't get the extension. You'll have to start all over again. Now, you want to get your doctors to speak of the CPP criteria when they're responding to letters. That can be hard to do. You don't want the doctor just to say, oh, my patient has a severe and prolonged disability. That's often not that helpful. You want them to talk about the types of limitations you have and how those are logically linked to the medical condition that you have. A key thing in all cases is you have to be able to demonstrate that you can't do any type of work. This is often a weakness in cases because it's common for people not to have a lot of attempts to go back to work or stay in the workforce. Often because maybe you had a long period where you were struggling at your job. And so once you couldn't do that job anymore, you felt like there's just no use to try other jobs and that kind of thing. This will always be something that comes up in a CPP disability case. Why didn't you try some other type of work? And that is a question you always have to be able to answer in your case. Now, sometimes maybe you didn't try other work, but you did a lot of modifications to your job that you had, and there's no other real easier work out there. Like that is often how you have to frame this, so that the court will be satisfied that you did try hard enough to stay in the workforce. All right, and key takeaways here. So being denied for insufficient medical evidence, it is fixable, obviously. It's one of the most fixable things. Sometimes they will tell you exactly what you're missing. If not, you have to kind of figure out for yourself what are the missing documents and get those to them. Now, legal help can be very useful here, whether from a lawyer or an experienced advocate, mostly because they'll be good at trying to identify what the information is that the court would need or Service Canada would need in order to approve the case. And again, don't take it personally, not that you necessarily would, but just because there's insufficient evidence, it's not meant to say anything about your disability. Sometimes they may even think in their gut would tell them that you probably are disabled, but they can't really approve the case if they don't have the medical records to justify it, because if they get audited, they could get in trouble. So you always will have to have the medical records to back up what you're saying about your level of disability. And that's always the challenge in these cases. Now, if you've been denied in one of these cases, you can always get in touch with us. You can ask questions here in the chat. That's why we're here. And there are links down below in the description of this video for free consultations and other resources and books that I have. All right, let's dive into questions here. So I've got some people telling me there's no sound. I appreciate that. I'm not sure what happened today. Both the normal camera and my normal mic are completely out of order. So I probably just have to reboot the computer, but that's what I get for not testing it before I wanted to go live. And here we are. So just let me know if anyone has any questions. In the meantime, I am going to be checking. Excuse me. I'm going to be checking to see if there's any more updates on the Canada Disability Benefit. I don't think there has been, but that is something that I know some of the people tuning in, they like to get those updates. Let's see if there's anything else here. No, I don't see anything new. Not seeing anything new. Not sure if anyone online here has put their application in yet, if you've heard anything back. I'm wondering how it went with the online applications. If anyone here's tried that, I'd love to hear how it went. We're probably going to get a lot of people giving statements on how it went here over the next little bit, I'm sure. So I haven't checked in for a while with our online forum, so let's go check that out. You guys can help me answer some questions. Let's go see the forum here. I'm just going to share my screen. There it is. Okay, take a look at this thing. So again, if anyone's new here, this is a forum that my law firm owns, runs, moderates. It's meant for people to get advice from others who are in the same situation as them. I pop in here just to kind of add my 2 cents and just, to moderate. Sometimes there are people in here causing trouble and things like that. So not that often, but let's take a look at this one. So this is a topic, CPP disability contacting new employer. Let's see what this says. So I just spoke with CPP disability today and informed that I am attempting to return to work after several years. Okay, that's good. They said they would need my new employer name and details. Does CPP contact the new employer? I do not want them to contact my new employer. Okay. Okay. So here we go. So yes, CPP disability will sometimes want to write to the new employer to ask questions. However, if you tell, however, I recommend you ask to be rolled in the, so this is someone who should get in the vocational. So they should be asked to go into the CPP disability vocational rehabilitation program. Then you can, then you will be assigned a coordinator. You can tell the coordinator you can yeah. The thing is, you've probably already signed forms that allow them to reach out to the new employer. So the best bet in this type of situation is simply to get involved in the vocational rehabilitation program. Then you'll have someone that you can actually get in touch with to, you'll have someone that you can get in touch with right away. Whereas otherwise you could be just calling into like a call center. I'm pretty sure you get a contact person once you're in the vocational rehabilitation program. You can then tell them that you would rather them not contact your employer, and then you can go ahead and do it. All right. Okay, let's see here. We got some questions, so let's just stop sharing that. Let's dive into some questions. How does CPP disability affect your long-term, what is LTC? Is that long-term care? Maybe that's long-term disability. I'm gonna go with that being long-term disability. How does CPP disability affect your long-term disability benefits, and what if CPP is denied? I was asked if my long-term disability application. I was asked in my long-term disability application if I applied. As I haven't, I was just beginning the process. Yeah. So this person is just confirming it is long-term disability. So the biggest thing for long-term disability is your policy likely requires you to apply for CPP disability benefits. So the biggest thing from their point of view is that you've actually applied, and this case you haven't applied yet. Now, if they ask you to apply, then you definitely have to, even if you'd rather not. It's part of your obligation under that policy, so it's better off for you to just do the application for CPP disability. Now, how does it affect it if it's denied? They have to still, the long-term disability and CPP disability are separate. So they do assess your claim based on their own criteria. There are I've had many cases where someone's been denied CPP disability, but still is qualified and approved for long-term disability benefits, and the long-term disability is fully aware of the CPP denial. They are different standards of disability, and it's quite possible to be approved for long-term disability, yet not meet the criteria for CPP disability. Now, if you are approved for CPP disability, then really you should be approved under most long-term disability plans as well. Now, the difference being sometimes they don't have the same information, and usually it means that the CPP disability has less information about you than the long-term disability, and so that is a reason why you might be approved for CPP disability, but the long-term disability says we don't care. We got more information than them, and if they knew everything we knew, then they probably wouldn't approve you either. I've had insurance company lawyers throw that back in my face a few times. All right. Now, if you just, this person, Patricia, if you just started the process for long-term disability, you don't have to run out and apply for CPP right away. Just wait and see. But if the insurer wants you to apply, then it is definitely something that you would have to do. All right, let's go on. We got another question here. This one says, I submitted my Canada Disability Benefits application with the code that came in the mail. Okay, perfect. You were on the fast track. They stated they will send a letter within 28 days from the application with the decision. The application was very straightforward. Okay, perfect. Perfect. So you were someone who was already on the DTC. You got the code in the mail. You've sent it in. 28 days is insane if they're going to be able to do it that fast. I know it's much easier for them. It's much, much easier. Like if you're already approved for the disability tax credit, then really all they have to do is check it's just a financial calculation. They just have to check your last year's tax return and figure out like what amount you would get. So let's keep our fingers crossed. Love to hear once you find out and hear from them. And I'd also like to see, like, if anyone's willing to share, I wouldn't make it public, but I'd like to see the letter they send back to you and what it says when you get approved, just to see what one of those look like. Okay, got another question here from Matthew. Hey, Matthew. What if I'm using your firm and add on LTD insurer release form that I do not want them to contact CPP disability since I am using representation to sort out the application and they respond? Okay. Then that's all you would need to do if our firm's representing you for the CPP disability. You could let the insurer know that we're handling the CPP disability and to direct any questions about the CPP disability to you. That should be fine. Yep, that shouldn't be a problem. That they will cut off my benefits. Okay, if they respond that they will, okay, you were saying, and what if they respond that they will cut off my benefits if I don't give them permission? They're never going to really come out and say that they're going to cut off your benefits if you don't give permission. Usually what they'll say is like, we're cutting off your benefits because we don't have enough information, and we don't have enough information because you didn't give us permission to reach out to things. Okay, now you do need to provide them information about CPP disability. The main thing that they want to know from CPP disability is they want to get, the LTD insurers want to have you sign a direction to pay so that when your CPP disability is approved, the Service Canada will automatically assess the amount owing to the insurance company and send it directly to them. That way the insurance company gets their money right away and they don't have to get involved with chasing you for the money and potentially suing you for the money and all that kind of thing. But yeah, certainly if you have a firm like us or anybody else representing you for your CPP disability, you could direct the insurer to contact that firm for information about it. Now, I would generally recommend that you just be open with the insurer and provide them with whatever they're looking for, like provide them with copies of the CPP application or information, that kind of thing. There's no reason really not to. It's better to be on the more open for information and give it to them. This person says, what to expect close to 2 year in LTD and get approved for CPP disability. Okay, so that is a common time. So once you're getting near 2 years on long-term disability, that means you're moving from the own occupation period into the any occupation period. The any occupation period of disability is similar to the legal criteria to get disability on CPP disability. Like the tests are similar. Often the CPP disability one is harder to meet. They're very similar, but they're still, CPP would be harder to meet. So what you would expect when you get near the 2 years, If you're approved for CPP disability, sometimes that can indicate that the insurer will also agree that you're unable to work and will simply approve you beyond the 2 years. However, not always. Even though you've been approved for CPP disability, they may take the view that you're still capable of doing some type of work, and you would expect them to be doing assessments. Like they would normally, close to the 2 years, they would be getting information from you about your work history, your resume, information about your abilities and things like that. They could be having vocational assessments done, either with you involved or just behind the scenes. But those are all things you could expect. You could expect a lot of activity in your long-term disability case leading up to the change of definition. That is most certainly, you should expect a lot of activity, questions, and information from your insurance company. But again, that's not the same in every case. This is still like there's not a standardization there, and it is still just differences based on the insurance company, the people involved, etc. All right, Patricia's got another question. It says, not related to CPP, but I'm wondering if it's appropriate to go above my LTD reviewer if he seems to be taking too long to provide his decision. He's had my medical records for a month. He said he'd try to review them in 10 days. I'm wondering if I should escalate or could that harm my decision? It will not harm your decision. It will not harm your decision. Like, I can't say that for sure, but generally speaking, this person's boss wants them to process things quickly. So like you pointing out that they're taking a long time to process it that's not something their bosses in the insurance company are going to be happy with. They want things processed quickly. Now, it depends on how long. Like you really want to give them about 30 days to reasonably get all the information and review it all and get a decision to you. If you're beyond 30 days, since they got the last bit of new information, so once they have all the information, it should be 30 days from that point. If you're beyond that, then yeah, you could go above their head, but I would still reach out to them again and get another estimate. Give them a couple chances before you go above their head. It's hard to go above their head because you don't know who to contact. You could ask them for their supervisor's name to contact them, or you could use the ombudsman's process for your insurance company. They all have an ombudsman process, and it's usually available on their website. You could do that. That is another way you can go around your case manager for service-related things. You can't use the ombudsman to say you disagree with their decision, but if it's like service issues with being too slow with things, that's absolutely something you can do with the ombudsman. Yeah, give it a few more weeks, but in the meantime, I would write to them. Like I wouldn't just give it a few more weeks. I'd write to them and put them on notice that they had indicated it would be ready by now, and can they estimate when a decision will be? Do that only if you've waited the 30 days. So wait the 30 days, and then if you don't hear from them, give them another notice. And then if you still don't hear from them, then you could go around them. That's probably the best thing to do. Okay, lots of good questions here. So let's dive back. I'll dive back over to while we're waiting for more questions, I'll go back over to the forum because we had a lot of stuff over there. All right. So I answered this first question. Let's see what else we got on here. Disability reoccurrence clause. Ooh, yeah, I love getting questions about this. So let's take a look and see what it says here. So this one says, I am attempting to go back to work after 6 years of LTD. It's with a different employer from the one I used to work for. Okay, that's very important to know. What are the specific questions I should be asking about the reoccurrence clause? I'm afraid that the injury might reoccur. My doctor and physio has supported me to go back to work. Insurance confirmed that I have 6-month period for reoccurrence. Okay, with different. Insurance confirmed that I have 6 months period for recurrence with different employer for return to work after I start working. I would love to hear your thoughts on what other questions I should be asking them. Yeah, okay, so let's think about this here. I have a strong probability that it might happen again. Okay. Oh, is that the same person? No, that's a different person. So what questions would you want to know? The reoccurrence is always tricky. Some things you would want to know about like I would want to see the reoccurrence clause myself, because here's the problem, like the insurer is telling you this, but they could be wrong. And if they're wrong, they can just say, whoops, we were wrong. You're still held to whatever the actual wording is, even if they were wrong. Okay. You can't rely on them. You still have to look at it yourself. So you don't need the policy itself, but you would want a group booklet that describes your benefits. 6 years you've been on LTD, so it's possible you don't have that group booklet, but I would ask them to show you it in writing, to get you a written clause of the reoccurrence just so you can see it. But from what they're telling you, it does sound like the right kind of clause. It doesn't restrict you from trying in a new job. Now, like some of the questions that can come up for the reoccurrence is that, does the reoccurrence start when you attempt to go back to work? So as soon as the attempt return to work, that's when the 6 months clause starts running? Or is it a situation where the 6 months only starts running once you're back to full-time hours first? So you could ask them, do I need to get, once I attempt the return to work, does the clock for the 6 months start running before I get to full-time hours again? So if you're working your way back to full-time hours, then you'd want to know, does the clock start running even if I'm not back at full-time hours, if I'm doing a gradual return to work? Or does it start as soon as I go back, no matter how much I'm working? That would be important to know. You'd want to get that clarified. And I'm going to put this in here. I'm just going to answer that. So 1, so number 2, so then if you're starting at less than full-time, working up to full-time, then you should ask when the 6 month clock starts. Or does it only start once you hit full-time hours? Bingo. Whoops. There we go. Good question. I love the old reoccurrence questions. Put my signature in there. There we go. Alrighty. Got another question coming through. So Lori, hey Lori, we'll welcome on in here. I'm on long-term disability through workplace accident. Signed contract for 40 hours, 2 days after I got hurt. They fired everyone. Oh boy. I was only working 20 hours and that's all I'm getting. What do I do? So it says here, so before I got hurt, I cut everyone's hours back about 25 hours where I'm supposed to work, getting paid for 40 hours. What do I do? Okay. Okay. So you basically, it sounds like you signed a contract for 40 hours a week, but but at the time you got hurt, you were only working 20 hours. And so they're basing your disability on the 20 hours, not the 40 that you were signed up to do. That's an interesting question. That is an interesting question. That is a very good. I don't know if I've ever had that come up. It says they cut everyone's hours. Typically, your long-term disability is only going to insure you for the actual time that you were working. And so there's a good possibility that, unfortunately, just the timing of this, you were only working 20 hours a week, that it could limit you to the 20 hours. But this is one where you'd really have to look at the wording of the insurance policy and also see, yeah, you'd have to look at the wording of the insurance policy. Now, you're saying a workplace accident. So normally with a workplace accident, you're going to be covered through workers' compensation. So when you're saying long-term disability, you may be referring to like you're getting long-term disability through WorkSafe, workers' compensation, WSIB, one of these programs. That would be different. I'd have to take a look at that. But again, they're more likely to focus on what was your actual work hours, regular work hours at the time you got hurt. And so there might be some dispute over that if you were on track to get to 40, if I'm understanding this correctly. But this could be something you could appeal if this is a workers' compensation claim. This is something you could appeal and have it reviewed by other kind of higher up people within workers' comp. I would say this sounds like just the workplace accident is what gets me to think this is a workers' comp case. And if it is, then it wouldn't be an insurance policy. You'd be dealing with the policies of the workers' compensation program that you're dealing with, whether that be, like I said, WSIB in Ontario, or it could be WorkSafe if you're in New Brunswick or BC. That's what it's called. In other provinces, it's just called workers' compensation. All right. All right, let's do one more question on the forum, and then I'm going to call it a day. Let's have a look here. We got another one. And if anyone else has any other questions, you can throw them in the chat. Let's have a look. So let's refresh that and see. All right, let's look at this one here. Oh, David's live webinar. What's that one? Oh, this person's asking. Yeah. Yeah. There it is. Okay, perfect, Caro. You gave the right thing. Let's have a look here. What does that link go to? And I think if you click there, it takes us to the YouTube. Yep. Okay. So that's all good. Thank you, Caro. All right. Let's look at what are we going to look at here? Let's look at this one. Options after 2 years. Okay. It says, hi there, just wondering, doesn't the employer have a duty to accommodate by putting this person in another job? I imagine the provincial government has vast numbers of jobs, unionized jobs even, that they could then put them into. Don't they have a duty to do that instead of just claiming frustration of contract? They bought the LTD insurance for employees. Doesn't that anticipate this scenario? Kind of feels like not a way not to accommodate. So Jammer's right. They do have to prove undue hardship. Yeah. So I think the thing is here, this is a complicated part about the duty to accommodate. Does the duty accommodate just apply to your own? And I'm just talking this out with you guys. So this person's saying, like, doesn't the duty to accommodate require them to put you in a different job if they can't accommodate you for the job you had? So you're working for an employer, you can't go back to the job you had. Doesn't the employer have a duty to accommodate you for other jobs? The answer to that is complicated, but generally speaking, it will depend on the wording of your employment contract, but if you were hired for a specific role within the company, they have a duty to accommodate you for that role. They do not necessarily have to accommodate you for other, like to create a new job or anything like that, or even to offer you other jobs within the company. That is also something that will sometimes be seen as a reasonable accommodation and other times may not be. So they don't necessarily have a duty to offer you other employment within the organization, but it is a fine line that sometimes if there are jobs that are similar enough to what you did before or that could meet your abilities, that could be seen as a reasonable accommodation for them to do to offer you other employment within the company. This is a good topic. I think what I'll do is I'll speak with Jen, who organizes all the topics that I do. This might be a good topic for me to discuss in one of my presentations, just to go into it in a little more detail and for me to refresh up, see if there's been any changes in the law around this. But it is a more complicated situation on whether an employer has a duty, does the duty to accommodate include you being offered other jobs within the company. The answer to that is maybe, but it would depend on the situation, your contract, and the type of work that was available. And certainly they do not have to create a job, but if there are other jobs there, that may fall under the employer's duty to accommodate. But you just can't assume just because it's the provincial government that they would have these jobs. They might, but again, like it depends on the type of accommodations people need. Like they don't have to accommodate. Most of their duty is tied to the job you had and accommodating you into that position. All righty. Okay, so Lori confirmed that she was working. She was working. It is a workers' comp situation, yeah, in Nova Scotia. And she's saying the company sold the business, then let everyone go so they could hire outside work. Ugh. Huh. Interesting. Hmm. So, Laura, you may not want to get into all the details about this. You could always contact us for a consultation if you haven't done so, for a confidential one. But I want to make sure I'm understanding your situation. So, is it that you were trying to go back to work there and then they let you go? The employer let you go? So not only like the LTD didn't cover as much as it should have, but you were able to try to go back to work and the employer just fired everybody. I'm just wondering if that's what's going on too. If that's the situation, I would recommend reaching out to us. There, you might have some rights there about being wrongfully terminated because of disability. But again, if they're firing everybody, again, we'd have to kind of look at the situation. And I don't think you necessarily want to put all your details here live on YouTube, but you could consider reaching out to us. The free consultation link is down below, and you can do that by submitting a form, or you can do a chat, and the chat is with a robot, but it's not a terrible robot, and it gets a lot of the information we need, and then our human people will see what you've told the robot and then reach out to you for the other details and stuff. All right, so if there's no other questions, I'm going to call it a day. We'll see. I'm going to I'll watch this back on my TV to see how this different camera looks. This camera is a lot easier than the other camera I use, so if this camera is better, then I might just stick with it. But if not, I'll go back to my other camera. Hopefully I'll have all the other stuff fixed for next time. Appreciate you guys jumping in. It was off a lot last week, so I'll be in the next 3 days. My mother is rolling into town hilariously on Thursday, so I'm not doing the stream on Thursday or Friday. So my mother's rolling to town on Thursday. I'm picking her up on the boat. She's taking the boat from Nova Scotia over to New Brunswick, and I'm going to go pick her up, and she's going to hang with us for a week. So I haven't seen her for a while, so this will be a lot of fun. And anyway, we'll be around the next 2 days. Come with all your questions, and I'll talk to you guys later. Have a good one.